principles that were distilled remain in place. For instance, on page 582, paragraph 20, the court says the following: as it is usually happens in matters of this nature, the parties in casu agreed that the evidence led by the state in the trial within a trial will form part of the main trial to circumvent a situation where the witness would have to lead the same evidence.
Yeah, that's the law I know.
And be subjected to cross-examination again. Yes, I think just underscores what
I've never heard of that. Never, ever.
what
Been in the criminal courts donkey years. Okay.
Yes. Then perhaps the last case then is that one of State versus Muchindu.
Yeah, that's where he says sometimes you can't differentiate between the evidence, which just read it also.
Yes.
Because Mr. Ngumalo once read it.
It's 2000, volume 2, SACR 313.
Yeah, what does it say?
Shoots
yeah.
Day, yes. It says, and I'm just reading the headline, the head note: it is not necessary for evidence which has already been led in the main trial to be led in a trial within a trial, if the parties wish to refer to such evidence, and the court is entitled to rely on such evidence. And then on page 317, at paragraph H, he says, accordingly, I rule that during the course of this trial within a trial, reference may be made to evidence already led in the main trial, and that the court is entitled to rely on such evidence as may be appropriate. My Lord, he's just saying that
the opposite.
Yeah,
that is permissible.
He's
for instance, the Colonel says I was born in 1920.
Yes. And
then
just
they can come in a trial within a trial. That evidence can be admissible.
Yes.
It's the other way around, because that is the merits being infused.
Yes.
Into the evidence in the trial within a trial, where it is common cause.
Yes. Yeah.
Okay.
And then lastly, the author Himstra criminal procedure at 2462.
2462.
Yes, 2462.
What's the Himstra?
In the heading repetition in the main trial of evidence given in a trial within a trial, he says, when there was a trial within a trial, those parts of the state evidence which are relevant to the main trial can be taken into account without being repeated. Says it is a necessary waste of money to repeat that evidence in the trial. Then he quotes the decisions of Nhlengetwa as well as Muchindu.
So basically those decisions are saying that what has transpired in a trial within a trial, meaning including the evidence which was led in the pro forma by the person who ultimately writes down the statement or the confession.
Yes.
And he or she has been cross-examined. So are you saying they're saying there is no procedure which says he must also be cross-examined on the evidence led within a trial concerning the pro forma?
Yes, that is the effect of the
that's
judgment
how I understand the law.
that we refer to.
Yeah,
Yes.
but it happens with any. He doesn't have to be in a trial within a trial. It happens, as Mr. Ngomezulu can tell you, it happens with any evidence. Once a witness has been cross-examined, you can't cross-examine him again unless you get a special dispensation from the court and unless there's a just cause which you present.
Yes.
Okay.
Okay. Then just finally, the writer Ditoi
what does he say?
and others' commentary on the criminal procedure at 2466H.
Yeah.
poses the question, if an accused's evidence during the trial within a trial cannot be held against him in determining his guilt, that is
Yeah,
now in the
you can't.
trial in the main trial, does this mean that those parts of the state's evidence relevant to his guilt can also not be taken into account? Then the writers say no, said the court in S versus Nhlengetwa, provided such evidence has been presented before the full court, including the assessors where they're sitting with the judge. It would be nonsensical and a waste of cost, time, and energy, said Haram's JA, to repeat evidence which was presented during the trial within a trial at the end of that procedure. He recognized that such a step might be a deviation from existing practice, and he also refers to the case of State versus Bakani and others, where the majority referred to Nhlengetwa's case in holding evidence adduced by the state at the trial within a trial to be admissible at the main trial for the purpose of confirming the confession. So in short, my lord, our contention is that the evidence of the witness who have been recalled, because basically this witness is being recalled, it's already testified.
That's it, yeah.
That, and I think that is the effect of the
law.
The submission by Mr. Ramsepeli and Mr. Ngomezulu that
Yes.
they continue from where they left off.
Yeah,
But
that's
just,
what the law says.
yeah, but just to avoid any uncertainty in this regard, we submit that the evidence of this witness, on all those witnesses who have been recalled, or to formally be injected or transplanted in the main trial.
Okay. Any response from any person, any counsel? Mr. Mgomezulu, you stand by what you said.
No response,
Mr. Amasepi,
As the court pleases, my lord, I hear the authorities and I cannot off the top of my head because the one that I had was the Kreischer one because
Which
I've
one?
got it here.
which one?
The Kreischer matter. But my concern, and I concur with Mr. Muniz, is this. There were certain parts in the pro forma that were redacted that the witness that's been recalled was never
They never
cross-examined.
testified on them.
So we leave them as
Yes.
that. Then I'm indebted to the
Even
court.
this court, you
Yes.
you all refused for this court against the law. You refused that I should know what is redacted. You remember?
No, I'm
You remember
indebted
that?
now.
You refused, and I said, okay.
Yes.
I even quoted case 1952, quoted an SAA case
Yes.
of 1952 which says, I can and I should. But I just abided with what you were saying.
No,
Now, those redacted parts, he was never permitted to read them.
Yes.
And they were never read. So he's not going to read them.
Okay, no, I'm indebted to the court.
Yeah. Okay, let's start. Can you swear the witness in again?
Your full names and surnames.
Moali Solomon Rappert,
Do you have any objection to taking the prescribed oath?
no.
If so, do you swear that the evidence you shall present in this court will be the truth, the whole truth, nothing else?